Now, hearsay was mentioned in the prior chapter in regards to documents, and we're going to get into it in a little bit more detail here in chapter 9. So first of all, what is hearsay? Hearsay is a statement that's made out of court by the declarant, the person saying it, and they're offering it to say that the statement is true, okay? But the problem is that it's generally being offered by somebody, it's not being offered by the pertinent, okay? Hearsay is, imagine I told you something and then you want to go into court and testify to what I told you. Okay? It's a statement. It can be oral, written, recorded. It can even be body language. And the declarant is the party who made the statement in the past. So it's something that's been made out of court. Someone is not making the statement in court by some other party, and someone is offering it as truth. So hearsay is not admissible, and there's a few reasons for this. First of all, the most important one is that it's a statement being made by somebody else. So that person isn't there to be cross-examined, okay? It makes it difficult for us to decide whether or not we think that that person's being truthful. So I could be lying about the content or what I recall. I could have misinterpreted what was said to me. And as I just mentioned, the defendant doesn't have the right to cross-examine them. However, there's a variety of exceptions to this. So testimonial hearsay is offered to the police or courts in prior cases. Testimony offered to the police or courts in prior cases is hearsay and is inadmissible, okay? So only if statements are made informally to assist law enforcement can they evade being hearsay. So for example, a 911 tape is not testimonial hearsay. So let's look at Crawford v. Washington from 2004. Mr. Crawford is on trial for assaulting Mr. Lee for trying to rape Mrs. Crawford. Crawford argues self-defense, claiming Lee had a knife. When interviewed by the police, Mrs. Crawford stated there was no knife. The statement to the police is testimonial hearsay and is inadmissible against Mr. Crawford. What you need is for Mrs. Crawford to come in and say there was no knife. You need her to be there to testify to that. Okay, what about if the person who has made the statement is no longer available? So testimonial hearsay, as I mentioned, is past testimony, and it may be admissible if the party again testifies. So there's several exceptions if the declarant, the person who made the statement, is no longer available. First of all, what do we mean by unavailable? Okay, they're not allowed to testify because of privilege. They're refusing a court order to testify, so they've been subpoenaed and they're just like, not going. They don't remember. They're unable to because they've passed away, they have a mental illness, or they're ill. Or they're absent and we're unable to locate them. So in Davis v. Washington from 2006, Mr. Davis is arrested for domestic violence. Michelle McCautry had called 911 and described an assault by Davis on herself. But at trial, she did not testify. The Supreme Court said that the 911 call could be used as it was not testimonial in nature. Therefore, it's not a violation of Davis's right to confront a witness. In a case from Massachusetts, Melendez-Diaz versus Massachusetts from 2009, Mr. Melendez-Diaz is charged with various narcotic violations for possession of cocaine. The prosecution introduces a lab report confirming the substance seized was cocaine, but they didn't call the technician who actually did the work, the person who did the testing and determined it was cocaine. They basically just provided a certificate. The court threw out that conviction, stating it is required that the defendant has a right to confront a witness testifying against him. So we need the technician to come in and to testify. Okay, what about an admission of a party used at trial against them? Federal rules say this is not hearsay, but most states do claim it to be hearsay and have some exceptions. In terms of practical applications, this could include things like a confession, or the practical application of this here is an admission of a party, so the confession, adopted by him, he agreed to the statement, authorized by him, order or directed, or made by an agent with authority. What about an admission by a co-conspirator? Some states do allow this, and it generally has to do with whether or not it's a conspiracy, whether or not there's a conspiracy, whether or not one of the charges is conspiracy. Federal Rule 804b3 talks about statements made against pecuniary interest, statements that subjects the party to civil or criminal penalties, or things that render a claim made by a declarant invalid. So this is when we make a statement against our own self-interest, okay? Things that basically could harm us or hurt us. Those are generally considered exceptions to the hearsay rule. Excited utterances, also called spontaneous statements. So a statement made after and about a startling event, but the statement has to relate to the event and the person stating it must be under stress. There's also what's called a contemporaneous declaration, which is also called a present sense impression, when a statement is made at the same time as an act. So this refers to a statement that describes an event that the witness perceived and a statement made immediately after the event. Dying declarations are also hearsay admissions, hearsay exceptions. This is a statement made by a declarant in anticipation of death about why they will die. So you're laying there, you've been stabbed, you think you're going to die, and you say, here's who did it. Okay? This is considered to be trustworthy because the phrasing in the past has been someone would dare not meet their maker with a lie on their lips. There's really not a motive to lie here. So Federal Rule 804b2 talks about this being a statement concerning cause of impending death. What about a statement made about mental, emotional, or physical health? Well, federally, this is governed by FRE 8033. This covers statements concerning mental or physical health. A statement of memory or belief is not admissible to prove a fact remembered or believed. So this is often used to show intent, plan, motive, emotion, pain, or state of health. And it can be useful, as I said, to show intent, plan, motive, emotions, and health. It's often admitted when a statement is made for the purpose of a medical diagnosis. We talked about reputation before. This is when someone admits what a person or community thinks of a given party. This is not admitted until the character is raised by the defendant. Remember, we talked about this before. Character evidence is usually not admissible unless the defendant makes it an issue. That covers the reputation of the defendant, the witness, and the victims. What about when a witness is unavailable but they've provided former testimony? That if as long as it's been made under oath, that and the defendant has had an opportunity to cross-examine them, so perhaps there was a deposition that occurred, that could be admitted as an exception to the hearsay rule as well. Prior statements, prior inconsistent, and prior consistent statements. Prior inconsistent statements are considered not considered hearsay under federal law in most states. They're often used to impeach a witness. Well, isn't it true in the past you said X, Y, Z? Prior consistent statements can be used to bolster the credibility when you're trying to rehabilitate a witness, and that's not considered hearsay in federal court. We talked about ancient documents. We tend to accept documents that are 20 years or older because of the difficulty of proving their validity now. And that wraps up the chapter on hearsay.